Greetings, class. I'm going to talk to you today about media law to augment our work for this week's discourse around, uh, freedom of speech, the role of media in our society, and what is the history behind it, and what are some of the laws to protect our rights, to give empowerment to media companies to do their role. Um, the press, the extent to which the press can be the unspoken fourth branch of government to govern our society, and the perils and other issues around the laws, the limitation of the laws, the ability of tech companies and social media and online platforms and so on to control things or not control things. So without further ado, I'm going to share a screen and go right to the presentation. And I will tell you that I have taken a historical approach to this short presentation just um, to put matters into the context of history that has always been a history in our democratic society about what the laws are and how the media play a role in shaping our society. So some of the wording in the slides may be small, so I'll read the ones that are tiny, but otherwise, you can read the slides easily here. And so what are the major roles of media in society? Well, obviously, the media outlets are channels of information and transmitting knowledge to the citizens of a democratic society. And they also provide what we learn about the world and beyond our own limited immediate experience. So, if free media in a free society means no censorship and accessibility has to be ubiquitous. And are, of course, one of the major roles that any media, whether it's television news, radio, print, and nowadays increasingly social media and online platforms for discussion and debate, is to facilitate um, civilized, informed debates. So we know that the First Amendment, the freedom of speech, freedom of expression, is a huge deal in the United States. It guarantees the citizens of the country five essential related freedoms: religion, speech, press, assembly, and petition. So we hear about this all the time, and cases are presented to the Supreme Court based on, the First Amendment all the time. And sometimes people judge them as fair, and sometimes they judge them as unfair. There's a lot of debate right now regarding, whether hate speech is part of this freedom of free speech, or should it be limited. Some countries like Germany, for example, do not allow any kind of speech that is deemed as hate speech. But in this country, it's controversial. And we'll talk about that some more later. So in 1798, the Alien and Sedition Acts was put in place. So it was illegal to criticize the government through Congress. And it only lasted 2 years, and historians have written that it helped Thomas Jefferson, win the presidency in 1800. Then in 1873, we see that the Comstock Act was passed, and it banned all sex education, birth control, and abortion information. And it also made illegal to send these materials through the mail. So we've had in this country a history of muckraking, and muckrakers are the ones that disturb the peace. They become whistleblowers, or they expose secrecies by government or powerful entities, big corporations, and so on. And as the label goes, they're muckrakers. So they influenced heavily the passage of laws in 1890 and 1906, the Sherman Antitrust Act and the Pure Food and Drug Act of 1906. So these acts led to the restrictions in how the media could advertise things. Although we are seeing the loosening of these acts, unfortunately, for some, where we see that alcohol consumption has gone up as a result of very attractive, very sophisticated advertising on television, magazines, and other places. And so that's another part of the current discourse around whether or not we should limit the content of advertising. The Espionage Act was put in place to sort of limit whistleblowing attempts. And the most famous case that one can think of is the case of Edward Snowden. And that, of course, we have and will continue to discuss in our discussion forum about the Edward Snowden and what he did by releasing information about how the NSA, National Security Agency, the government, was spying on all Americans and then also going beyond American borders and spying on world leaders and so on. By the way, there are two films about Edward Snowden that I highly recommend. One is a documentary known as Citizen 4 that you can watch, and it was an award-winning documentary. I believe it gave it an Oscar, but I'll verify that and then confirm it on our discussion board. And then the other one was a dramatization of what happened with Edward Snowden by Oliver Stone called Snowden. Very good films, and I highly recommend them. So in 1919, Justice Oliver Wendell Holmes wrote, the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that the United States Congress has a right to prevent. And this is known as the doctrine of clear and present danger. And we have seen movies and literature made around this idea of clear and present danger. And oftentimes, this doctrine is applied to notions and activities around national security. So from the very beginning, as broadcasting became a thing in our society, and nowadays is 24/7, we have the 24/7 news cycle, 24/7 entertainment cycle, and we have 24/7 streaming of movies and television programs and documentaries and so on. So FCC, Federal Communication Commission, regulates broadcasting, and they regulated more than radio stations on frequency spectrum. They also did the equal time rule that was in place. Stations must give equal opportunity for other candidates of the same office during the election times and so on. And the fairness doctrine was implemented in 1949. However, during the Ronald Reagan's presidency in 1987, it was removed. And this was a doctrine that required broadcasters, to television and radio, to give time for discussion of big public issues to both sides and not just one side. Telecommunications Act of 1996 did a lot of things to change the landscape of media in this country. It removed restrictions on a wide range of communication industries, cable TV, long distance carriers, local phone companies. One could say that it was a good thing that this act was put in place and signed by Bill Clinton, the president at the time. Nowadays, you can basically make long distance calls for free, whereas prior to 1996, companies like AT&T, MCI, and so on would charge a lot for making simple long distance calls. But it also did something else that critics say was certainly bad for a democracy, and that is allowing the consolidation of the ownership of media. If you recall, at the beginning of the course, first couple of weeks, we talked about convergence culture, cultural convergence, technological convergence, and also media ownership convergence, where a handful of companies can own a bunch of media companies. And that always is not a good thing for competition or broadening a multitude of perspectives that should be available to folks who watch TV or are online looking at these news outlets and so on. Let's shift back to the 1950s. In 1957, the Supreme Court decreed that a work could be declared obscene. So the definition tended to confuse rather than clarify, because what is the definition of obscenity, right? Nudity was considered at the time obscenity, where today, on cable TV, we can see nudity. And one could say that instead of focusing on nudity, they could have focused on violence, particularly today, because the amount of violent acts that we're seeing in television programs, and it's just freely produced and reproduced and streamed, and they keep raising the bar with it, is beyond realistic. And it is a problem that one could call obscene. In 1964, Justice Potter Stewart expressed frustration at the difficulties of defining obscenity. He famously said, "I can't define it, but I know it when I see it." So a new category of indecency was created for broadcast controls at the time. In 1996, coming back to 96, Congress passed the Communications Decency Act. Now, this is in addition to the Telecommunications Act. It made it a crime to transmit indecent material over the internet if minors had access to it. So that would have been, right, minors having access to pornography. But today on the internet, all you have to do is, when you go to like a porn site, is just press that button saying, asking you, are you over 18? And a 12-year-old kid could see that and just press, yes, I'm over 18. And then voila, things open up to them. The Congress, the government, parents, society at large, if you like, people who are concerned about these kinds of problems, haven't been able to find a solution of how to curb this access to indecency on the internet, and particularly the internet. However, there are people that say, well, if you're going to start censoring these things, then we're going to introduce the possibility of censorship about everything. And then in a free society where freedom of speech is guaranteed to us by way of First Amendment, we cannot have censorship. So that's an argument that merits much discussion. Other laws had to be written for crimes that did not exist before the internet. So in 96, computer espionage was illegal. In 90s, federal law made the development and purposeful transmission of computer viruses illegal. And this continues to be a problem today. So what type of laws we have? We have the criminal laws and we have the civil laws, and we also have constitutional laws. Any state or local law that contradicts the First Amendment cannot be legally implemented. That's part of the constitutional law. So dispute between individuals where they sue one another, that's part of civil law. And criminal law, of course, right? You go steal a car, right? It's a criminal act, and by the laws that we have in our country, the person who gets arrested and proven that he was the car thief will be punished by the law, and supposedly it's proportional punishment. All right, so a person could go to jail for years, or he could go for a few months and be released on probation, etc. There's the statutory law, there's the administrative law, and the common law. The common law is made up of judges' rulings, which become precedents for future cases, and lawyers use the common law often in either defending a case or prosecuting a case, depending on what side they are, the plaintiff or the defendants. So governmental agencies use rules and regulations to basically govern different institutions and also oversights for private institutions, and that is under the umbrella of administrative law. Now, the statutory law is a vague kind of a notion. It's a collection of laws written by legislative bodies, like the U.S. Congress. So, and they gain a certain statute. So, and that's why they're known as statutory law. And again, the lawyers as well as lawmakers use the statutory laws to make their cases, to pass new laws, to get funding, to move their agenda, and so on. But law is the law is the law. Now, what happens with the media in relation to law is quite important, particularly in cases that are deemed as defamation or slander. There's a difference between these three different categories: defamation, slander, and libel. So defamation is false communication that injures the reputation of a person, usually a well-known figure, like a politician or a celebrity. Slander is the type of defamation that appears in spoken form, such as a speech. Politicians get away with slander constantly, yet an average person who may get access to some kind of a media platform, such as Twitter, now known as X, or Facebook or something, and writes or speaks into video form, say on YouTube video, defaming a person could be punished severely by way of usually a civil lawsuit. Now, libel is when something is published, a defamation is published or broadcast on television, and so on. In most cases, the truth is what sets the parties apart. So it is the onus put on the public figure to prove the actual malice of the kind of free speech that was deemed as libel or defamation or slander. Oftentimes, it's very difficult to prove these things. So when you see something that has a copyright sign, it doesn't mean that that's all you need to do to protect the original creative idea, whether it's a painting or a book or just a written paragraph about a story idea or something. It must be registered with approved agencies. Say, for example, you write a screenplay and you're concerned that somebody might steal this screenplay from you and go sell it and then make a movie out of it and all that and become rich. What do? Just putting copyright with your name doesn't protect it. Although it should be done, but you can go to the Writers Guild of America and then register your screenplay. There's a small fee. It used to be $15. I don't know if it has changed in 2024, but it is usually quite affordable to pay this fee and then have your screenplay, for example, registered with them for a period of what used to be 3 years, but now I think they, with a certain fee, they can extend it to 5 years. And then you can renew that, of course. Or when it expires, then it's fair game. Now, you can copy a work for non-commercial use, as long as it doesn't exploit the copyright holder. Say, for example, some of the images I've used in this presentation, it's solely for the purpose of education. I'm not making any money off of this. I'm not claiming that this is mine. So I'm not exploiting or harming the original artists that have created this thing. And it's out there in the public for this kind of use. Now, if I decide to grab this slide presentation, turn it into a video, and then sell that video, then I have broken the law, and or rather abuse the Fair Use Act, and then a civil lawsuit can be brought against me. So certainly I'm not going to do that. Then there is the Digital Millennium Copyright Act, which is it makes it a crime to break through any technology intended to secure digital copies of software, literary works, videos, and music. This is when people, pirate videos and so forth, which is difficult to prosecute. So we know that some forms of speech are certainly more protected than others. There's political speech, there's artistic speech, there's commercial speech, and there's indecent speech. Indecent speech, as you might guess, must and does enjoy the least protection. Now, political speech is when ideas are presented, and if they are presented with facts, then they're highly protected, because a politician should back up his claims or her claims with facts. But in reality, we see many politicians willy-nilly offer ideas and things and say things about the groups of people without having the facts in their hands or presenting the facts. Oh, these people are criminals and things like that, what they say, and they lump a whole bunch of people because maybe one out of 10,000 immigrants might have committed a crime and say, oh, all these immigrants are criminals and so on. Unfortunately, political speech gets much protection, even when it's abused like that. Artistic speech is protected. So make sure that if you are in the world of creative works, painting, even dance and literature and producing nowadays, every one of us has the ability to be a content producer through digital technologies that are available to us. And remember, your production enjoys protection. We have laws in place for that. Now, I took out this Pew Research Center slide to illustrate the level of support for free expression. What countries have the highest level of support and what countries don't. You might find this graphic statistical graph somewhat surprising when you look at some of these countries. Obviously, United States is right at the top, given our commitment to First Amendment. Poland, and that was surprising to me the first time I saw this slide, is at 5.66, and that's pretty high for a country that is not really well known for lots of freedom of speech and so on. And yet, facts are facts. And Pew Research Center, this nonpartisan research organization, they have a great reputation, and they back up all of their studies, the surveys, and everything with proper data and facts. So I trust the numbers here that we're seeing. If you notice, Ukraine, the support of free expression in Ukraine is kind of low. It's right there, even below Burkina Faso or Lebanon, if you like, or even Turkey. Turkey has more support of freedom of expression, free expression, and Russia is even higher than Turkey. Of course, the countries in the green are the ones that are most supportive of free expression. Now, four major themes emerge about the future, right? As I said early on at the beginning of the presentation, said that we need to think about the online social climate. Now, the four themes, these letters are small, so while you're watching this video, it might be difficult reading them. So I'm going to go ahead and read everything here. Some people say, and these are critics, professionals, people that think about these things, and the average citizen, of course, is part of this, that things will stay bad because the troll is human. Anonymity abates bad behavior. Inequities are motivating inflammatory dialogue, and the growing scale and complexity of intent discourse makes this difficult to defeat. We know that trolling is a major activity online. Maybe you have witnessed it. Maybe you've been a victim of trolling, or maybe you've done some trolling of your own while on social media. Sometimes this is playful, um, like when celebrities troll one another, and sometimes it is with malice, and that's where the problem occurs. Trolling and other destructive behaviors result from a disconnect between anonymous actions online and consequences that might flow from those actions. The ever expanding scale of internet discourse and its accelerating complexity make it difficult to deal with problematic content and contributors. It is a problem that we have not found a solution for as of yet. Theme number two, and this is also from Pew Research Center as a result of uh, much study and interviewing professionals in the field. Things will stay bad because tangible and intangible economic and political incentives support trolling. Participation equals power and profits. Hate, anxiety, and anger drive participation, which equals profits and power. And we've seen that happen recently. The tech executives of social media companies were brought to Congress to respond to what they're going to do about this problem online. And it was a long ordeal. And I did post on our discussion forum for some folks, and also an announcement, I believe, this PBS NewsHour program on this hearing. But perhaps I'll post it again as we continue our discourse around the activities online. Technology companies have little incentive to rein in uncivil discourse, and traditional news organizations, which used to shape discussions, have shrunk in importance. So this is another theme. Another dangerous theme is terrorists and other political actors are benefiting from the weaponization of online narratives, implementing human and bot-based misinformation and persuasion tactics. Theme number three, and this is on the good side of the equation, perhaps one could say. Things will get better because technical human solutions will arise as the online world splinters into segmented, controlled social zones with the help of artificial intelligence. Now, there is much hope about AI being able to implement new plans of curbing and mitigating the amount of trolling and misinformation and fake news and disinformation that gets spread around online because AI can work constantly, right, 24/7, and much faster than, say, you and I can go and look at things and research them, delete one thing and add another thing, offer op-eds and so on. So AI can be quite beneficial in this sense. So there is room for much optimism in this regard, provided the actors are ethical actors, people who put these AI programs together. So regulation also comes into play. AI sentiment analysis and other tools will detect inappropriate behavior, and many trolls will be caught in the filter. Human oversight by moderators might catch others. So it's a combination of human and AI working together in this sense. There will be partitioning, exclusion, division of online outlets, social platforms, and open spaces. Now, for that to really happen and become a practical idea, I believe that a breakup of major social media companies would be necessary. And one could say that that is a major solution to the problem we're having now, because the more competition is around, the more perspectives are offered, so we can see different sides of any idea, notion, issue, and be able to do this business of partitioning and divisioning of the online outlets. Number four, the oversight and community moderation come with a cost. Some solutions could further change the nature of the internet because surveillance will rise, The state may regulate debate, and these changes will polarize people and limit access to information and free speech. There's always this fear of government interfering with everything and surveillance um, being a part of like turning a free society into a police state. And there's always that fear. So, to what extent the oversight should be given in the hands of the government, or could it be a combination of democratically elected common citizens working in coherence with government agencies dealing with these things? So, is hate speech free speech? Every time hate speech is permitted, it costs someone part of his or herself, part of their self respect, or part of their sanity. It rips people to shreds and destroys society. So the argument goes as such that hate speech is anything but free. That is the end of my presentation on media law. And like I said earlier, this is meant to augment our work online. So let's continue the discussion. Let's get involved, offer our points of view predicated on the material that's available on the Canvas site, the website, other sources that you may gain access to with your research and going in depth in discussion about our relationship to laws and the media, the intersection of law, media, and the average citizen. So I'll see you online.